Hi, listen, welcome to the training for the mock trial teams for the Youth and Government competition in 2014. We are excited to be here, and I want to give you some opportunity in this training video to be able to watch this over and over again, or take as much time as you need to do that. Let me say at the start who I am. I'm Mark Davis. Been doing this a long time, and I've been training mock trial teams for a long time. And let me give you an email address so that if you want to contact me with particular questions, I will be happy to help you in any way, shape, or form. And don't think because I'm a youth and government coach that I'm going to somehow slant things in any way, shape, or form, because I would not do that. My email address is maldavis, D-A-V-I-S, at greenville.k12.sc.us, and I will get back to you quickly with emails. As a matter of fact, in the past, people have emailed me, or students have emailed me with particular questions about experts and objections and how do we handle things in court, and some great questions come up, pretrial motions, etc., limine, all those things. So let me start out by sort of going through how a trial actually proceeds, since some teams this year will most likely be new. First off, we have a murder case this year. Criminal cases have to be won with what we call overwhelming evidence. So when you do an opening statement, you're representing the prosecution, or the state as we say. And when the state brings its opening statements, one of the things you're going to want to say is that we will prove beyond a reasonable doubt. And that is actually what's called the burden of proof in a murder case or a capital crime case. So it's important for you to use those words in your opening statement. The question becomes then, what happens after that? So let's talk about the order, and then I'll talk about each individual part if I can. The state, when you come into the courtroom, the judge will generally have all of the witnesses stand, or all the teams stand and introduce themselves, and then he will say, let me go ahead and swear in the witnesses, and he'll swear them in generally all at one time, so you don't have to worry about doing that individually when they come to the stand. And then what will happen is the judge will look at the prosecution team, and he will say, is the state ready to proceed? And one of the attorneys on that team should stand. It doesn't really matter which one, but they should stand and address the judge and say, yes, Your Honor, we are ready. The state is ready. And then he will look at the defense team, the opposite team, and say, is the defense ready to proceed? And the same thing should occur. One of the attorneys should stand and say, yes, Your Honor, the defense is ready to proceed. And once you do that, he will say then to the state, can you bring your opening statements, or will you bring your opening statements? And then that gives you an opportunity to step up. Now, it's sort of a personal choice whether you want to stay behind your table. You'll be seated at a table as an attorney, or whether you want to come out from around the table and move up towards the judge, who will be seated up a little bit higher than you are. It's really a personal preference. I recommend that mine come out from around the table. But you want to talk directly to the judge, and you want to give what's called your story. And then in this particular case, they actually sort of almost give you that story. If you look at the sort of the background information of this case, they sort of lay that out for you. Now, what you'll do within that opening, and then I'll talk about it in a minute, is you'll kind of bring out a theme and some other things. Once you finish, then the defense will come and give their opening statements, and then once they're seated and they're finished, the judge will look at the state and he will say, is the state ready to call its first witness? And what you'll do is, again, you'll stand. Whichever attorney is directing that witness or doing a direct examination of that witness should stand and say, yes, Your Honor, we call this person to the stand, and say their name, and they will come to the stand. And what you should really do the very first time for a judge is you should say something about, if it please the court, or may it please the court. You really only have to do that one time. You don't have to do it every time. But it's sort of one of those courtroom decorum things, and we're pretty particular in court about being kind and courteous to everyone and treating everyone with respect, and certainly the judge. And so you would say something like, Your Honor, may it please the court. And he'll say, you may proceed. When he gives you that chance to proceed, go ahead and do a direct examination of your witness. And when you are finished, you say, I have nothing further, or you can say, if you want to be more formal, we hand our witness over to the defense. And then they get a chance to what's called cross-examine that witness. When that is done, if you feel like you need to redirect your witness, you can then ask them one or two more questions. The general recommendation is not to ask more than about one or two questions on redirect. Now, if you decide to redirect a witness, then the defense would get another chance to what's called recross the witness. Remember that they may only recross the witness on what you direct or you redirect. So that's kind of important to remember. Once that is done, you call your second witness. Remember that the attorney who will be doing the direct exam would stand and say, Your Honor, we call our second witness to the stand, or he'll ask, do you have another witness, and call them. And you'll go through that procedure each time with your three witnesses. And when you're done, you will say, Your Honor, the state rests. And then it's the defense's turn. So then the defense will call their first witness to the stand. They will direct that witness, and then you will get a chance as the state to cross-examine their witness. And again, after all three of their witnesses have been called and cross-examined, then everybody rests. And what the judge will do is he will generally ask if the teams would like a few moments to adjust their closing arguments. And it's a pretty good idea to say yes. Some teams feel like they've already pre-written their closing arguments and they have nothing to add. Generally, what you want to do is you want to take a few moments, and anything that has come up in court during the trial that maybe you hadn't thought of, or maybe you want to add into your closing argument now, this is a good time to write that down. And then the judge will generally give you about 3 or 5 minutes, and you adjust your closing arguments, and then we come back. The judge will say, is the state ready to proceed with its closing arguments? You say, yes, Your Honor. Do your closing arguments. The defense will then get a shot. The only difference in a criminal case is that you, the state, get one last opportunity to do a rebuttal. So you get one last opportunity to come after the defense has brought its closing arguments and do a rebuttal. The defense does not get a chance to do that. So only the state in a criminal trial gets that opportunity. When all is said and done, the trial is over. The judges have pretty much been instructed, if I'm correct at YIG, is not to render a verdict. Now, they may want to do that. They may want to say, in this case, I would have probably, found for the state or found for the defense. But we generally recommend they do not do that, because if they render a verdict, some of the teams feel like they won the case, or they won, or they beat the other team. And what we've done at Youth and Government, very much like the South Carolina Bar mock trial system, is that we've incorporated a point system so that you win by points. So you win by performance. Witnesses win by being very good witnesses and being believable and knowing their affidavits. And attorneys win by presenting their case very well, being very respectful in the court, and understanding and knowing objections and how they handle themselves in the courtroom, sort of thinking on their feet and those sorts of things. So again, sort of points also, having said that, for attorneys sort of goes along with, do you really know your material, or are you just reading off a sheet? If you're just reading off a sheet, then you're not as sophisticated. You're considered to be not quite as sophisticated as an attorney who knows the part a little better and doesn't have to read each question. They kind of know where they're going, they kind of understand. So that's kind of how the points work. Witnesses should not ever use their affidavits on the stand unless they're being impeached or something, which I can talk about in a minute. All right, so let me get a drink of water. All right, let me talk specifically about sort of each part of the trial, and then I'll hold objections till last. And let me talk about opening statements. When you give opening statements, basically what you're doing is you're telling your story. They'll say our second witness will come to the stand and they will tell you these things, and our final witness will come to the stand and tell you these things. And then you sort of want to give a little summation, and you want to say at the end, and Your Honor, at the close of this case, we will have shown beyond a reasonable doubt that the defendant, and you should use that word, the defendant is guilty of murder, and you should find as such. And so sort of wrap the case up like that. You can introduce yourselves as attorneys at the beginning or the end, it doesn't matter. And I'm not so sure that's the important part. You want to remember that the state is your client, and you want to represent the state. So the defense is the same. Now, one of the things teams typically get confused about as they're newer at mock trial is they feel like the defense has to sort of prove something. It's always true, no matter whether we talk about criminal or civil, that the defense never has to prove anything in a case. Your job, if anything, is to muddy the water, is to show why they did not do a good job, why the state has not proved its case. And you do that through your witnesses by showing how things are a little different, or interpretations are a little different of what they said, or those kinds of things. So remember that the defense's job is never to prove. That is the job of the state or the prosecution. And while we don't allow what we call trial motions or mid-trial motions, if the state failed in chief to bring their case or to prove their case, before you even called your first witness, you could effectively stand up and say, Your Honor, we move for dismissal because the state has failed in its burden of proof. Now, we don't allow that in mock trial simply because we have to score witnesses. So if the judge actually felt you were right and the state had not proven its case, he would declare a verdict for you, and we would dismiss, and we'd never hear your side of the case. And we obviously want to do that. So again, the same is true for both sides. You do want to bring a case in chief. When you call your witness, it's called your witness, and you do a direct examination of them. And this is the most critical part. When you direct examine your witness, you sort of want to bring them in an order in which the story happens. So if you have somebody who can basically tell the story, maybe not an expert, but somebody who can tell the story of what happened, that's the person you want to bring to the stand first. So don't just think they're always in the correct order that they're given to you in the trial materials. Sometimes they are, sometimes they are not. And then you'll notice as you read the affidavit, which are all signed and documented, by the way, we don't allow you to challenge that in mock trial, that somebody didn't sign it correctly or it wasn't authorized. It kind of almost walks you through how you should direct your witness and how you should get their story out during the trial. And what you should do is you should always ask on direct examination only open-ended questions. I can honestly tell you that the typical first and second question are just about the same for every witness. And the first one is, can you state your name and occupation for the court? If you want to include their age and you think that's relevant, you can certainly do that. The second question, which is designed to lay a foundation, and I'll talk just a moment about that, is very simple one. It's, how are you involved in this case, or can you tell us why you're here today? And again, you can ask that maybe in a different way, but it's the same question. And what that does is that second question allows the witness to lay proper foundation for you. I'll give you a good example in this case. One of the first witnesses you're going to want to call as the state most likely is, and I'm sorry that I remember his name, but it's Blast, Mr. Devin Blast. And so when you ask the question, the second question, how are you involved in this case, or why are you here today? Mr. Blast is going to say something about, well, I'm really good friends with the defendant. I've known them for years. And the young lady that's missing, we've been friends since elementary school. And he might say, we party together, we do those other things together, some of that. And what that does is that gives you a basis now, because he's told you I'm friends with the defendant, and I'm also very good friends with the person that's missing. It gives us an opportunity to ask about those people. Because we can't just go to the third question and say, tell us about the defendant, until we know that this witness knows the defendant. We can't talk about the parties and what happened at the parties until we can establish or lay foundation that there was a party and that this witness was at the party. So that's what we call laying a foundation. So always remember that you have to lay that foundation piece first before you can ask about it. You can't ask about the defendant until the witness says they know the defendant. You can't ask about the young lady that's missing or whoever it is that's missing until he mentions that. You can't talk about the parties until you know or he mentions or she mentions there is a party. Okay? And so you sort of see how that works. You have to lay a proper foundation. If you do not, it's pretty simple. Opposing counsel's probably going to stand up and object and say, Your Honor, lack of foundation. And that tells you, okay, it doesn't mean you're in trouble. It means now I need to go back and do it. So you need to say, where were you? And he says, well, we went to a party. Okay, let's talk about that party. Who was at the party? How did they act at the party? And again, that may be opinion, may not. It kind of depends. We'll talk about the objections in a minute. But you kind of see how that works. Now, the defense or the opposing counsel is going to get a chance to cross-examine your witness. And these are what we call leading questions. You always want to, always, and I cannot say that enough, you always want to ask leading questions on cross-examination. So the question becomes, and I think we know that Devin Blast admits in his affidavit he was toasted at the party. So you may want to bring that, and the way you would ask that is, you were toasted at the party, weren't you? And sometimes we have to use the weren't you, didn't you, couldn't you. We have to sort of use those initially with a witness to sort of clarify that we are asking only a yes or no question. So on a cross-examination, make sure that you are always leading the witness. Having said that, let me back up and say that you may not lead in a direct examination. You must only ask open-ended questions. Okay, who was at the party? How did they act at the party? You can't say they were acting a certain way at the party because that's a leading question, and only leading is allowed on a cross-examination. So remember that and keep that in mind. And when you do a cross-examination, one of the things that generally gets an attorney in a little bit of trouble on a cross is that you ask, the question is, let me back up a moment, the question is too long. If you've got 3 or 4 or 5 or 6 things that you want to get out, and you generally really need only about 3 things out of a witness, no matter how long it takes you to get there, keep your question short. You said you were toasted. Isn't that correct? Weren't you? Okay. You said that she was acting a certain way, didn't you? Okay. You don't want to say you were toasted and she was acting this way, and Sam, you don't want to ask compound questions. You want to keep them very short and succinct and to the point so it's easy for the witness to just say yes or no. And try to make sure that's what they say. If a witness goes off and starts expounding on other things, although you're not really allowed to cut the witness off, you can try to make sure that you keep them short and then say, so that was a yes or that was a no. And then move on to your next question. And that's just really important, and it'll help you to keep it on track and make sure that you get the witness to admit to or agree to what it was you want them to say. Once you've finished all your witnesses and then the defense has brought it to all its witnesses and you've done your case in chief and they've done their case in chief, then it's time for you to close or do your closing arguments. And again, this is a very critical part of the case. The reason we call it closing arguments is this is where you get to argue why the state is correct and why this person is guilty of the murder. You can bring in lots of other argumentative details which you're not allowed to bring up in an opening statement. In an opening statement, you may not literally bring up information that's argumentative. He was always angry is argumentative. Now, if he yells, then we can say that. If he was at the party, we can say that. If he was the last one in the car, we can say that. But we cannot say, he was angry and he shot her in the head, and we can't. Those are argumentative things that have to be argued during the trial in direct and cross-examination. So remember, on closing, you want to argue your side. You want to argue very strongly for your side. And then you want to say, Your Honor, you must find for the state. Don't ask, Your Honor, please find for the state. You want to say, Your Honor, you must find for the state. We have proven beyond a reasonable doubt that the defendant is guilty of murder. All right? And on the defense, you obviously want to now argue why the state has failed in its burden of proof. They did not prove that there's been a murder. We don't have a body. We did not prove, because we have a missing witness, what was said at that final hour. We don't even know that this person has not run away to college, or not college, but run away from home or something. We have no idea. Yes, there's blood in the car, but that blood could have come from a bloody sneeze. And so, again, you're kind of, if you will, muddying the water of the state's case. And you want to argue very strongly for that. And then you want to say to the judge, Your Honor, you must not find guilty. You must not find the defendant guilty because the state has failed in its burden of proof. They have failed to prove beyond a reasonable doubt that someone was actually murdered in this case, or that the blood in this case belonged. I don't know, however you decide to argue this thing is pretty important. All right, and again, if you have questions, my email's there. I hope you will email me, and I would be happy to help you in any way I can. All right, I'm going to take a drink of water, and then I'm going to talk about objections. What happens during a trial is that there are certain objections that come up. They most often come up on direct examinations, not that they can't come up on cross, but they most often come up when the opposing counsel feels that there's something inappropriate. There's going to be inappropriate testimony offered at trial. Like, I think this defendant is a really bad person. Obviously, that's an opinion. And I bring that one first because the most common objection in court is opinion. And so if one of the witnesses on the stand says, he was a bad person, or I think he was really mad, or I think he killed her, or I believe, or I think, or any of those kinds of statements, those tend to be what we call opinion statements. They're opinions, and you kind of have to back opinion up with something. Now, so the opposing counsel, if you hear something like that, the opposing counsel will stand and you will say, Your Honor, objection, opinion. Or even before the answer comes out, you can say, Your Honor, the question calls for opinion. How do you think he felt is an opinion question. You're asking them to give an opinion about how someone else felt about something. So be careful with those kinds of things. There are two arguments on why a witness may give an opinion. And we're talking about a lay witness here, not an expert. Every witness is lay unless they're experts. And there are basically two arguments on why we should be able to court to hear this opinion from the witness. Number one, it's a rational perception. So let's talk about what that means for a moment. And again, because this is the most common objection that comes up at court. Devin Blast has been friends with the defendant and the young lady that's missing since they were in elementary school. So it's a rational perception that Devin Blast knows how they talk. He knows how they act together. He can kind of tell when one of them's angry, when one of them's sad, when one of them's hurt. They know each other real well. And so understand that that's your first argument. Your Honor, this is not opinion because it's a rational perception. This witness has known the defendant for a very long time. He's known this young lady since elementary school, and therefore he understands. The second part of the argument is just as important, and that is, how does this information, how does the opinion of this witness help the judge make a decision in this case? Or if it were the jury, it would be the jury. We'll call the fact finders. How does having this opinion in testimony help them to make a determination? It might actually be not helpful. It might actually, what the opposing counsel might say, it actually prejudices the judge against the witness. If I were to say, oh, I think the defendant was just a really angry person all the time and he hated her, or he was jealous of her. that might be more prejudicial than it is probative in value. And so the opposing counsel might argue, Your Honor, it is rational. It's a rational perception. He knows this person and would know that when they're an angry person. But the idea here, Your Honor, is we're in a murder trial, and having that information in, just because he's an angry person doesn't make him a murderer. So you have to kind of determine and leave it up to the judge how to rule on this case. Now, or in this objection. Remember, too, that you always want to argue strongly for your side. Don't yell or scream. Remember courtroom decorum. But you want to argue strongly. Don't just let it go. If the objection comes, Your Honor, this is opinion, it's an opinion question or an opinion, then you want to argue why it's not an opinion. And the opposing counsel might want to come back with another argument. That's, again, more sophisticated attorneys who will come back and say, but Your Honor, having that information to the court might prejudice the court against my witness. It might, and that might not be good for the court to hear necessarily. And remember, always argue to the judge and never each other. Don't look at the opposing attorney and argue with them. Always argue to the judge and let the judge make a decision. And the judge is going to either sustain the objection, meaning, yeah, he thinks it is an opinion, or whatever it is you bring, or he overrules the objection and he's going to allow that testimony in. Having said that, I want to bring up another point. Don't get discouraged. It's critical to understand not to get discouraged if you get overruled a couple times. I have seen many, many times with new attorneys in court, you get overruled a couple times because you didn't maybe argue it real well, or maybe the judge didn't feel you were right, and you sort of take that as a sign that the judge just doesn't, he's going to overrule every objection you bring. It is so important to not let that bother you. You keep objecting if it's an important objection. It's really important to remember that. Don't take it as a sign that the judge is not going to ever side with you, because that's not correct. The judge has to be fair, and that's what a judge's job is to be fair in the case. And so he's not going to let in information in this case to a jury or himself that could prejudice him in any way. So try to always keep that in the back of your mind when you're raising objections, is that sometimes you're going to win, sometimes you're going to lose an objection, and that's okay. You're being scored on how well you know the objection, how well you know the rules of court, and how strongly you feel for your side. And that's important to remember, because it's not about verdict, it's about points in mock trial. All right? So again, that's the most common objection. The second most common objection that comes at trial is what we call the hearsay objection. And I can honestly tell you that this is probably the most sophisticated court rules. Attorneys themselves will often argue about this particular rule and how it applies and what it means. And I have been in many, many trials where judges after the fact will say, well, this is what hearsay was and this is what it means. And when you go to another court, you hear the same testimony and another judge will say, no, that's not what it means. So even they sometimes get rather confused sometimes about what hearsay means. Let me give you the definition of hearsay. The definition of hearsay is any statement, written or oral, verbal from me, or from the witness, that is not their own statement, and people tend to forget the last part, is being used to prove the truth of the matter asserted. So that's kind of an important point to remember. So if I'm a witness on the stand and I say, Julie told me, that's hearsay. I heard them say is hearsay. I have this document here. I didn't write this document. That's a hearsay document. Okay? It's not one that I wrote. It's not a statement that I made. Now, does that make the document the truth of the matter asserted? Not necessarily. Does that make the statement the truth of the matter asserted? If I said, Johnny told me he really loves his mother, that's probably not a statement that goes to the truth of the matter asserted. But if I say something like, Johnny told me that he was planning on killing her, that's probably to the truth of the matter asserted. So you have to sort of displace a little bit in hearsay, because there's lots of hearsay that comes up in trial, you have to kind of determine what's really important first and what's not important first. Because there are some things that are hearsay that we're probably going to want to hear, and we really need to hear at trial. We do need to hear some things that other people who aren't here say, and some things that they can't. Now, there are what we call some exception rules, and one of those is it's not hearsay if it's called the party opponent rule, and this one comes up fairly frequently. So let's take an example. Let's say that I have Devin Blast on the stand, and he says, the defendant told me that she was accusing him of plagiarism. All right, hearsay statement, he told me that she was accusing him of plagiarism. So we got kind of a dual thing going on here. All right, that's hearsay. Now, is the defendant in the courtroom to testify? Yes. And so sort of the first argument against hearsay is, Your Honor, the defendant is in the courtroom to testify on that matter. And that's sort of the first part of what's called a hearsay, not hearsay exception. And if they're here in the courtroom and they can testify to that statement, then it's probably okay. Again, it depends if it's the truth of the matter asserted or if you're using it for that purpose. So that witness is then going to either get on the stand and they're going to verify that statement, or you've got their affidavit, you know they're going to get on the stand and deny that statement. And so you say, Your Honor, under party opponent rule, the defendant is here to testify, and they're going to tell us on the stand that that statement is not, they're going to deny that statement, or they're going to say that statement is correct. And then you got to let the judge rule. The judge could say, well, I think this is hearsay and I sustain, or I overrule. I think it's okay for us to hear it. And we'll hear it again when this defendant gets on stand and somebody asks him about it. So kind of important. Under the 803 rules, there are generally what we call exceptions to hearsay. And it doesn't mean they're not hearsay. What it means is they're sort of allowed to happen. And under 803, some of the most common ones are that we get in these cases is we get police reports. And we get these documents like the blood analysis report, and we get the bullet analysis report, and we get the police report of the broken in, or the house that was broken into, other things. And what we don't have is we don't have the police officer who took that report in the courtroom. So we have the police report filled out by an officer, and I don't remember in this case if they are or not here, but if the officer who made out that report is not present, that makes the document hearsay. It's a hearsay document. However, under the exception rule, if another police officer or an expert who normally looks at these kinds of reports is in the courtroom to testify, we can say, Your Honor, this is an exception rule under 803, and this witness does this in the normal course of their duties. And again, that's probably the most common 803 rule that comes up. Or, Your Honor, this expert is he's talking about, I rely on this information, but his textbook that he uses for that he learned from is not in the courtroom. That makes it hearsay. And you can say, Your Honor, under 803, the materials that this expert relies on do not have to be present in the courtroom for us to accept them. And again, that's one of the 803 exception rules that comes up. Otherwise, experts would never be able to almost testify about other documents either. So again, I don't think there's a lot of that in this case, but you can kind of keep that in the back of your mind about hearsay. The other exception that comes up in this case, and I'm going to actually probably just go ahead and turn to it, and that's called the 804 rules. And under the 804 rules, this is when the declarant or the person who is being testified about is not available to testify. And we have two of those in this case. We have a gentleman who has joined the Army and has been shipped away, and we don't have his testimony in court. We don't have his affidavit. And then we have the young lady herself who has been assumed to be murdered, or the charges are murder, or she is not available to testify. And so under 804, it's called the hearsay exceptions when the declarant, the person who made these statements, is unavailable to testify. All right. The exception here is They are unable to be present or to testify because of death or physical or existing physical or mental illness or infirmity. So under Rule 804, number A4, as we say, or you say 804, there's an exception to this young lady who is not in court, who the state is going to say has been murdered. And so we can sometimes bring in statements that she made. Devin Blast is going to talk about some things she said, and I'm sure the defendant will, and some other people. And they're going to use that 804 exception, that, Your Honor, she's unavailable to testify, we're going to say because of death. Now, pretty interesting. I don't think the defense actually wants to say she's dead. But again, we can under that exception bring in some of her statements. But you must keep this in mind. If those statements that the other witnesses make go to the truth of the matter asserted, that someone hurt her, killed her, harmed her, had plans on harming her, then those statements, even though she's unavailable to testify, would not be admissible because they go to the truth of the matter stated, even under an exception rule. See, again, you always try to keep that truth of the matter asserted in your mind. The other one is that they are absent from the hearing or they have been unable to procure the declarant's statement based on the fact that they have an exemption or refusal or claim. And in this case, we have an exemption because the young man has been, Joe, I believe it is, Joe's situation has been called away to the Army, and he's unavailable. We don't have his affidavit. So, again, you may be able to bring some of their statements into trial, but be careful. Be careful when someone brings their statements that you know that statement is not being used to prove the truth of the matter asserted, in this case by the state. So I'm giving the defense a little bit of a leg warning here to watch that carefully. Make sure the state isn't kind of pulling one over on you. They're using these statements because they're going to say she's unavailable due to death, and you're going to want to argue that's not the case here, that she's unavailable for other reasons. So kind of interesting, and make sure it's not to the truth of the matter asserted. All right. I hope I made hearsay clear. It's a tough rule. And you're welcome to email me and ask me questions about that one as well. Some of the other, I'll try to open this back up real quick. One of the other ones that comes up generally is foundation. We talked about that initially. John, tell us what happened at the party, but you've not established there was a party or John was at the party. So you need to lay that foundation first. That objection comes sometimes. The other one that comes up is relevance. So John, how old are you? Well, I'm 19. Objection, Your Honor, relevance. Does it matter that he's 19? It may not, but relevance comes up. So, Your Honor, they're asking a question that has nothing to do with this trial. And it's stuff that we should disregard. We don't need to hear. And so that's what we call relevant evidence. So remember to do that. The other one that I think is probably critical is what we call opinion testimony by experts. Now we have 3 experts in this case, if I'm correct. We have a blood expert, we have a bullet expert. Actually, I think we have 2 blood experts. We have a blood expert on the state side and a blood expert on the defense side, and we have a bullet expert on the state side. Always remember, be careful when people ask questions, and I'm going to talk about how to get an expert witness in just a moment. Be careful that the questions they ask the expert are in their area of expertise. So if we have a bullet expert and he's been qualified as a bullet expert, you want to object if they ask the bullet expert a question about blood or about what he thinks happened in this case. You want to be very careful that they may only testify in their area of expertise. If they testify to anything outside the area of their expertise, then you object and you say, Your Honor, objection, that's an opinion. And it's opinion outside the expertise of this witness. And so generally you'll be upheld pretty well. And I can honestly tell you, teams are pretty good at getting that stuff in with experts. So you want to be careful that they are asking that expert questions in their area of expertise. Now there are a lot of documents in this case. and there's lots of blood evidence and DNA evidence. I think there's some DNA from the hair, which the expert will be able to testify to, and the bullets and where they got the bullets, and does it match the gun, and is there landing groove marks on the bullet, and all those sorts of things. And then the other expert is going to talk about the bloody sneeze and the blood patterns and all those kinds of things. I can honestly tell you to read all of the documents very carefully. I'm pretty sure I'll have to go back, and I don't want to speak out of turn, but I'm pretty sure that all of the exhibits in this case are entered or have been predetermined to be entered, that there's no real objection to any of the documents. That doesn't mean you don't have to sort of fight them in. They are what they are. If we've pre-stipulated the documents, I'm not so sure. I haven't read that. I don't think I've read that part, and I'm not sure they're pre-stipulated, meaning that you may be able to argue to keep some out. A curriculum vitae, I know one of the witnesses has a curriculum vitae, and that is basically a resume. So let me talk about experts, because I think that's where I'll end today. When you bring your experts, first of all, let me tell you that you generally want to bring the expert at the end. They hit the home run for you. Those are the guys in your story who kind of put it all in a sock and say, yep, he murdered him. Here's her blood, and this is the bullet, and whatever that case may be. You qualify a witness in with 3 questions. So when you call the witness to the stand, you say, can you state your name and occupation for the record? And then you'll ask 3 questions. First of all, can you tell us about your education? And that should come from the curriculum vitae. If they do not have a curriculum vitae, then it's probably written in their affidavit where they went to school, where they got their specialized whatever from, their certifications, etc., etc. I went to this college, I have a bachelor's, I have a master's, I have a doctorate, or whatever that case may be. And then you say, so can you tell us about your training? The second question is, can you tell us about your education, excuse me, can you tell us about your training? And so then he could say, well, I've had special training in blood analysis, or I've had special training in this, or I've been spending years going to these classes or taking these special courses, or those sorts of things. And then the last one is, can you tell us about your experience? And so then you want your witness to say, yeah, I've been doing this for so many years, and I'm recognized in my field as being whatever. And you need 2 of the 3 things in order to qualify your witness as an expert. If you are weak in these areas, then opposing counsel can ask to not allow this witness as an expert. So you want to be careful that you ask all 3. Can you tell us about your education? Can you tell us about your training? Can you tell us about your experience? Get 2 of the 3, and then you would say to the court, Your Honor, we ask that this witness be qualified as an expert in, and tell us what area. If you can get more than 1, that's to your benefit. So they're a blood analyst, or a blood expert, blood pattern expert. They're a bullet analysis expert, or bullet expert, or they're something else, a DNA expert, or whatever that case may be. So try to qualify them in as many areas as you can, and make sure that their education or their training or their experience line up with what you're trying to get them as an expert in. And while that sounds a little silly, I've seen teams actually slip by other areas of expertise that they didn't actually qualify them in, and some teams will automatically not object. And they've got that person as an expert, and then when they ask them a question, all of a sudden the opposing counsel goes, oh, wait a minute, Your Honor, that's outside the area of expertise. And the attorney says, oh, no, Your Honor, they accepted the qualifications. The court accepted their qualifications in that area. And so it's critically important that you listen very carefully to what it is they're qualifying the witness as an expert in. And I can honestly tell you that sophisticated teams are very good at slipping in some extra areas of expertise to help their case. So again, just be a little careful with that. That's how you qualify a witness. The only other thing is I'm going to talk about how to enter an exhibit, which you have, I think, 9 or so in this case, and then how to impeach a witness. And I want to make sure I clearly state that. So, okay. So clearly, if you're going to bring an exhibit, first thing you do, you bring your expert. They're mostly with experts, and you bring your expert to stand, and you say, ask them a question. Did you do a police report? Did you take a police report? Or did you analyze the blood? And when your witness says yes, you say, Your Honor, you stand, or you're already standing, you say, Your Honor, we move to enter, we'd like to enter this exhibit, or may I show you what has been marked as exhibit, whatever it is. Show it to the judge, make sure you kind of show it to the opposing counsel, and then say, may I approach the witness? Approach the witness, hand them the exhibit, and say these things. Can you identify this by title? And they'll say, yes, this is the blood, whatever, this is the bullet, whatever, this is my curriculum vitae, whatever it is. And then you say, is it true and accurate? Yes. Get them to say yes. Step back and say, Your Honor, we move to enter this exhibit into evidence. You don't have to say anything else. You don't have to be any more formal than that. The opposing counsel has a chance to stand up and object to it. But if you've done those things, then there should be no problem getting that document in unless it contains some kind of hearsay or something. I don't think anything here does. I think you're okay. All right. Once you have that in evidence, it has to be entered before you can use it. So make sure that he can't read from it, you can't ask questions about it, you can't do any of that until it's been entered into evidence. The second thing I want to talk about just for a moment is impeaching a witness. If a witness purposely, or you think purposely, tells an untruth on the stand, don't call him a liar in court. All right? That's kind of not courtroom decorum. You can say, you're not being truthful with us. You can even say on closing arguments they were an untruthful witness, but you don't want to call them a liar in court. So what you do want to do is you want to use their affidavit. My recommendation is you number every line in the affidavit so you know right where the answers to all your questions are when you do a cross, okay, even on a direct. So if the witness said something that's not correct in their affidavit, it's called impeaching the witness, and you say, Your Honor, may I approach the witness with their affidavit? And the judge is going to give you permission. Make sure the opposing counsel may say, Your Honor, may we see what they're handing their witness. Make sure they are clean copies. You may not approach the witness with an affidavit that you've marked or highlighted or done anything else. So make sure you have clean copies of everything in this case before you go to court. All right? Ask permission to approach the witness. Show them the affidavit. Say, is this your affidavit? Yes. Was it taken under oath? Yes. Is it true and accurate? Yes. Now, you can do it one or two ways. The best way is for you to read it. So you read what is incorrect in their statement. Read it out of their affidavit to the court. Just read it. And then say, is that your statement? Or you can just leave it alone. You've read it and you can move on to the next question. What you've done is you've impeached the witness. You haven't been mean to the witness. You haven't been ugly to the witness. You haven't done anything else. You haven't called him a liar. You haven't made fun of him in court. You're not badgering the witness. You're not trying to embarrass the witness or anything else. You've impeached him. And you've shown the court that this witness's testimony is not accurate, that they are telling a different story now than they were before. And then move on. Make sure you note that for the closing arguments. Ladies and gentlemen, I hope I have helped you in some way, shape, or form and helped your mock trial team. And again, if you need any help at all, I'll be happy to do that. Happy to answer any questions you have. And I want to wish you the best luck possible, and I look forward to seeing you at YIG 2014. Thank you.